You see the flashing lights in your rearview mirror, your heart starts pounding, you pull over, hand over your license and registration, and then something happens that most people don't expect. The officer finishes writing your ticket, hands back your documents, and you think, okay, I'm done. But instead of walking away, the officer leans back into your window and says, hey, you don't mind if I ask you a few more questions, do you? Or maybe, you don't have anything in the car I should know about, right? What do you do? What do you say? Most people freeze. They think, well, the officer is still standing here, so I must not be free to go. And that's exactly what the officer is counting on. Because here's what most people don't know. There is one simple sentence you can say that will end almost every traffic stop, and it's backed by the United States Constitution and the Supreme Court of the United States. That sentence is, Officer, am I free to go? In this video, I'm going to explain exactly why this sentence is so powerful, when you should use it, how to use it, and what happens when the officer says no. I'm also going to walk you through the Supreme Court case that gives you this right and how to protect yourself if cops try to extend your traffic stop beyond what's legally allowed. Let's get into it. First, let me explain why this question is so important. You see, under the law, there are three types of police encounters. The first is called a consensual encounter. This is when an officer walks up to you, maybe asks you some questions, but you're free to leave at any time. No suspicion is required for this type of encounter because it's supposed to be voluntary. You can literally walk away. The second type is called an investigative detention, also known as a Terry stop. This is when the officer has reasonable suspicion that you've committed, are committing, or are about to commit a crime. During this type of encounter, you are not free to leave. The officer can detain you briefly while they investigate. The third type is an arrest, which requires probable cause. Now here's what most people don't understand. A traffic stop starts as an investigative detention. The officer had reasonable suspicion or probable cause to believe you committed a traffic violation, so they had the legal right to pull you over. But here's the critical part. The detention has an expiration date. The moment the officer completes the purpose of the traffic stop, whether that's writing you a ticket, giving you a warning, or running your information, the legal basis for holding you is gone. At that point, you should be free to leave. The problem is, cops don't always tell you when the stop is over. They know that most people don't know their rights, and they use that to their advantage. This brings us to the landmark Supreme Court case that changed everything. Rodriguez v. United States, decided in 2015. In this case, a Nebraska police officer pulled over Dennis Rodriguez for driving on the shoulder of the highway. The officer completed all the routine tasks of the traffic stop. He checked Rodriguez's license, ran his registration, questioned him and his passenger, and then issued a written warning for the traffic violation. At this point, the purpose of the stop was complete. The officer should have let Rodriguez go. But instead, the officer asked Rodriguez for permission to walk a drug-sniffing dog around his vehicle. Rodriguez said no. Did the officer let him go? Absolutely not. The officer ordered Rodriguez out of the car and made him wait about 7 to 8 minutes until another officer arrived with a K-9 unit. The dog alerted, and a large bag of methamphetamine was found in the vehicle. Rodriguez was charged with federal drug crimes. He moved to suppress the evidence, arguing that the officer had violated his Fourth Amendment rights by prolonging the traffic stop without reasonable suspicion. The case made it all the way to the Supreme Court. And in a 6-3 decision written by Justice Ruth Bader Ginsburg, the Supreme Court ruled in favor of Rodriguez. The court held that, and I'm quoting here, a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. The court went on to say that the authority for the seizure ends when tasks tied to the traffic infraction are, or reasonably should have been, completed. What does this mean in plain English? It means that once the officer has done what they pulled you over to do, whether that's write you a ticket or give you a warning, the stop is over. They cannot hold you any longer unless they have separate, independent, reasonable suspicion that you're involved in other criminal activity. And here's the really important part. The court explicitly rejected the idea that a short delay is okay. The government argued that 7 to 8 minutes was de minimis, meaning it was such a small intrusion that it shouldn't matter. The Supreme Court said no. Even a brief extension of a traffic stop, if it's not supported by reasonable suspicion, violates the Fourth Amendment. So this brings us back to that magic sentence. Officer, am I free to go? This question is powerful for several reasons. First, it forces the officer to make a choice. Either they have to tell you that yes, you're free to go, in which case you can leave immediately. or they have to tell you that no, you're being detained, in which case they now have to articulate a legal basis for continuing to hold you. They can't just keep you there indefinitely because they feel like it. Second, this question creates a clear record. If the officer says you're free to go and you leave, the encounter is over. If the officer says you're not free to go and they don't have reasonable suspicion, then anything they find after that point may be suppressed in court. Your attorney can argue that the continued detention was unconstitutional and that any evidence obtained as a result should be thrown out. Now let me walk you through exactly how this should work in practice. You get pulled over. The officer walks up, asks for your license and registration, and you provide it. Maybe the officer asks you some questions. Remember, you have the right to remain silent under the Fifth Amendment, so you don't have to answer questions about where you're going or where you've been. But let's say you choose to answer some questions politely. The officer goes back to their car, runs your information, and either writes you a ticket or decides to give you a warning. They come back to your window, hand you your documents, and that's when the stop should be over. But many times it's not. The officer will stay there and start asking more questions. Hey, by the way, you're not carrying anything illegal in the car, are you? Or, you wouldn't mind if I took a quick look in your car, would you? This is the critical moment. This is when you say, Officer, am I free to go? If the officer says yes, then thank them politely and drive away. Don't stick around. Don't continue the conversation. The stop is over. Get out of there. If the officer says no, you're not free to go, then you need to ask the follow-up question. Am I being detained? And if so, for what reason? The officer must be able to articulate specific facts that give them reasonable suspicion to believe you're involved in criminal activity. They cannot just say, I have a hunch, or you look nervous. Nervousness alone is not enough. Courts have repeatedly held that being nervous during a traffic stop is not a reliable indicator of criminal activity. Think about it. Who wouldn't be nervous when they're pulled over by a police officer? Now, here's something really important. If the officer says you're being detained, do not resist. Even if you believe the detention is unlawful, your job is not to argue with the officer on the side of the road. Your job is to protect your rights for court. So what do? You say, Officer, I do not consent to any searches, and I exercise my right to remain silent. Then you close your mouth and let your attorney fight it later. If the officer conducts an unlawful search or extends the stop without reasonable suspicion, any evidence they find can potentially be suppressed. But you have to preserve those rights by clearly stating your objections. Let me give you a real-world example of how this plays out. Let's say you're pulled over for speeding. The officer writes you a ticket, hands it back to you along with your license and registration, and then says, "You don't mind if I have my K-9 partner walk around your car, do you?" You say, "Officer, am I free to go?" The officer says, "Well, I'd like to have the dog walk around your car first." Now you know something important. The officer just told you that you're not free to go. So your next question is, am I being detained? If the officer says yes, you say, on what basis? The ticket is issued, and I'd like to be on my way. The officer either has to articulate reasonable suspicion or let you go. If they don't have reasonable suspicion and they make you wait for a dog, they just violated Rodriguez. Any evidence the dog finds could be thrown out. Now let me address something I hear all the time. People say, Jeff, if I ask, am I free to go? Won't that make the cop suspicious? Won't that make things worse? Here's the reality. You're either going to protect your rights or you're not. The officer already has whatever suspicion they have. They either have a legal basis to hold you or they don't. Asking a simple, polite question about whether you're free to leave doesn't give them any additional evidence of anything. What it does is clarify your legal status and create a record that protects you later if things go sideways. Remember, the Constitution gives you these rights. Exercising them is not an admission of guilt. It's not suspicious. It's exactly what you should do. Now let's talk about what you should not do. First, do not physically resist. If the officer tells you that you're being detained and you try to drive away, you could be arrested for obstruction, evading, or worse. Even if the detention is unlawful, you fight it in court, not on the side of the road. Second, do not lie to the officer. If you choose to answer questions, be truthful. Lying to a police officer can get you charged with obstruction of justice or making false statements. If you don't want to answer a question, the better choice is to simply say, "Officer, I exercise my right to remain silent." That's not lying. That's exercising a constitutional right. Third, do not consent to searches. I cannot stress this enough. If the officer asks to search your vehicle and you say yes, you have just waived your Fourth Amendment rights. At that point, the officer can search your entire vehicle, and anything they find, whether it's yours or not, whether you knew it was there or not, can be used against you. Always say, "Officer, I do not consent to any searches." Now let me address a common scenario that trips people up. The officer gives you your ticket, you ask if you're free to go, and the officer says yes. You start to pull away, and then the officer says, "Hold on a second." Can they do that? Well, it depends. If they're calling you back because they forgot to give you something or there's some legitimate safety issue, that's probably okay. But if they're calling you back to ask more questions or to search your car, that's potentially a new detention that requires new justification. The key question is always, does the officer have reasonable suspicion to detain me? If not, any continued detention after you've been told you're free to go is constitutionally suspect. Let me also explain what reasonable suspicion actually means. Reasonable suspicion is a legal standard that's lower than probable cause, but higher than a mere hunch. It requires specific, articulable facts that would lead a reasonable officer to believe that criminal activity is afoot. Things that might establish reasonable suspicion include the smell of marijuana or alcohol, seeing contraband in plain view, erratic behavior suggesting intoxication, or making statements that suggest criminal activity. Things that typically do not establish reasonable suspicion include simply being nervous, refusing to consent to a search, having an air freshener in your car, or traveling on a highway known for drug trafficking. Courts have been pretty clear that these factors alone are not enough. Now I want to address what happens with passengers. Under the Supreme Court case Brenlin versus California from 2007, when an officer conducts a traffic stop, all occupants of the vehicle are considered seized for Fourth Amendment purposes, not just the driver. This means passengers have constitutional rights too. They can exercise the right to remain silent. They can refuse to consent to searches of their person or belongings. And if the stop is unlawfully extended, they can challenge evidence found as a result of that extension. So if you're a passenger and the officer hands the driver a ticket and the stop should be over, you too have the right to ask, "Officer, am I free to go?" or to at least encourage the driver to ask. Let me walk you through the exact steps you should take during a traffic stop. Step 1. When you see the lights, pull over safely, turn off your engine, roll down your window, and keep your hands visible on the steering wheel. Do not make any sudden movements. Step 2. Provide your license, registration, and proof of insurance when asked. In most states, you're legally required to provide these documents. Step 3. If the officer asks questions beyond the basics, you can choose to answer or you can say, "Officer, I exercise my right to remain silent." Either way, be polite and respectful. Step 4. Do not consent to any searches. If the officer asks to search your vehicle, say, "Officer, I do not consent to any searches." Step 5. Once the officer has completed the purpose of the stop, either by issuing a citation or a warning, ask the magic question, "Officer, am I free to go?" Step 6. If the officer says yes, thank them and leave promptly. If the officer says no, ask why you're being detained and then exercise your right to remain silent. Now here's something that catches a lot of people off guard. Sometimes officers will try to turn what started as a traffic stop into what they call a consensual encounter. They'll hand you your ticket and then say something like, "Hey, I just want to have a friendly conversation. You're not in any trouble." At that point, technically, the traffic stop is over. You're in a consensual encounter, which means you can leave at any time. But here's the trick. The officer is standing right there, maybe blocking your door, and most people don't feel like they can just drive away. That's why the question, "Am I free to go?" is so important. It clarifies whether this is truly consensual or whether you're still being detained. And remember, if they tell you you're free to go, believe them and leave. So let's recap the key takeaways. 1. A traffic stop has a limited duration. Once the officer has completed the tasks related to the traffic infraction, you should be free to go. 2. Under Rodriguez v. United States, police cannot extend a traffic stop beyond what's necessary without independent reasonable suspicion. 3. The question, "Officer, am I free to go?" forces the officer to clarify your legal status and creates a record that can protect you later. 4. If the officer says you're being detained, do not resist, but exercise your rights by remaining silent and refusing to consent to searches. 5. Your refusal to consent to a search cannot be used as evidence against you. 6. Always be polite and respectful, but be firm in asserting your rights. Remember, police officers are trained to extend traffic stops and fish for evidence. They're trained to ask questions that make you feel like you have to answer. They're trained to ask for consent to search in a way that makes it sound like you have no choice. But you do have a choice, and that choice is protected by the Fourth Amendment to the United States Constitution. When you ask, "Officer, am I free to go?" you're not being difficult. You're not being suspicious. You're exercising your constitutional rights, and that is your right as an American citizen. One more thing I want to address. What happens if the officer ignores your question? What if you ask, "Am I free to go?" and the officer just doesn't answer or deflects with another question? This is a common tactic. The officer might say something like, "Why, do you have somewhere to be?" or "What's the rush? Don't take the bait." Calmly repeat your question. "Officer, I'd like to know if I'm free to go." If they still don't answer, you can say, "Officer, if I'm not being detained, I'd like to leave." At this point, if the officer doesn't give you a clear answer or physically prevents you from leaving without articulating reasonable suspicion, they may be violating your constitutional rights. But remember, don't physically resist. Just make your intent clear, verbally assert your rights, and let your attorney handle the rest. I also want to talk about recording the encounter. In all 50 states, you have the right to record police officers performing their duties in public. During a traffic stop, you can use your phone to record the encounter. This recording can be crucial evidence if the officer violates your rights. Some officers may not like being recorded, but it is your right. If an officer tells you to stop recording, you can politely say, "Officer, I have a First Amendment right to record this encounter, and I am not interfering with your duties." Place your phone on your dashboard or have a passenger hold it. Just don't make any sudden movements that could be interpreted as threatening. Finally, I want to remind you that knowledge is power. Most people get taken advantage of during traffic stops because they simply don't know their rights. They don't know that a traffic stop has a limited duration. They don't know that they can refuse to answer questions. They don't know that they can refuse consent to a search. And they definitely don't know about that magic sentence, "Officer, am I free to go?" Now you do. And that knowledge can make all the difference between a routine traffic stop and a situation that spirals out of control. Now, we just covered the one sentence that can end most traffic stops. But what if the officer claims they smell marijuana in your vehicle? Did you know that in many states, the smell alone is no longer enough to search your car? Check out this next video where I break down the new rules on marijuana odor and exactly what to say if cops try to use this trick on you. See you over there.